under these circumstances, as she provided the false name willingly upon the officer's request, nor did it address the issue of whether she could be punished for refusing to provide her name in the first place. Accordingly, despite the trooper's vague assertion otherwise, there does not appear to be any case law in Florida that directly holds that passengers are required to identify themselves during traffic stops.
Or obstruction. I'm not too. They fall underneath the same statute or in the same category. What she's being charged with is that. What case law means is the interpretation of what they're supposed to be.
She got arrested because she was sitting passenger seat and she didn't give them her ID, so they just arrested her. For not giving them her ID as she didn't commit a crime and was just sitting passenger. So.
And here's your last citation for not showing me proof of insurance. Any questions for me?
I have proof of insurance.
All right, you didn't show it to me. I asked you for your license, registration,
I handed it to you and you walked away.
You handed me 2 registrations and a license. You didn't hand me your insurance.
Well, it's on my phone.
All right, great. Show it to the courthouse. All right, you have 30 days to take care of the tickets. You need me to explain to you how to take care of the tickets?
No, I'm good.
Don't open the door on me. Thank you. You need me to explain to you how to take care of your tickets?
No.
All right, have a great night. I don't care how you feel about me. Once you go inside of here, they're two separate entities. You treat them with respect, you do whatever they tell you to do, your process goes a lot smoother in here. All right? You're going to have to ID yourself, or they're not going to process you. You'll be sitting in here till you give the name. Do you understand that? Do you have any questions on that? Are you going to tell me who you are now? Or
I'll tell them.
Okay, that's perfectly fine.
The driver was arrested and transported to a detention facility for booking. Very little information is available about this encounter, and the outcome of the charge is unknown. Overall, the Martin County troopers get an F for demonstrating a serious lack of knowledge regarding both the First and Fourth Amendment, maintaining hostile and authoritarian demeanors throughout the encounter, and arresting a citizen for simply attempting to exercise her constitutional rights. Perhaps even more concerning than the troopers' behavior is that this appears to be a department-wide training issue rather than an isolated incident, as every trooper involved seemed to believe that they were within their authority to identify passengers during traffic stops, with one of the troopers even calling a supervisor, who referred him to the Johnson versus Noco case to back up his position. As we discussed earlier in this episode, not only did this case not include a majority precedential opinion regarding the constitutionality of identifying passengers, but even Judge Joe Flatt, who was the most amenable to the troopers' position that they were permitted to identify passengers during traffic stops, did not conclude that there was no constitutional violation in doing so. Rather, he determined that it was a quote-unquote open question, and therefore that the officers were entitled to qualified immunity, particularly when considered in combination with the very clear precedent established by the Supreme Court in the Brown versus Texas case, where the court held that it violated the Fourth Amendment to require citizens to identify themselves when officers lacked any reasonable suspicion to believe that they are engaged in criminal conduct. The Johnson versus Noco case in no way sanctions the identification of passengers without reasonable suspicion, and it is highly disturbing to see the Martin County Sheriff Office misinterpreting the law in this way in order to demand identification from citizens who are not suspected of any wrongdoing. The passenger gets an A+ for refusing to identify herself when there was no lawful basis for the troopers' demands, physically submitting to the arrest while continuing to decline the unlawful orders, and being willing to face arrest in order to stand up for her principles. It takes immense courage to endure an unlawful arrest in defense of one's beliefs, and I would not have faulted her in the slightest for complying with the demand for identification under threat of arrest, particularly given the fact that she's not a First Amendment auditor or a constitutional activist, as far as I'm aware. I sincerely hope the passenger is able to successfully challenge what I believe are entirely baseless charges against her, and I encourage her to file a complaint and seek legal representation if she has not already. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to pick up your copy of the Civilian Rights Hand Guide in the links below. Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers the First Amendment, flashing headlights, and retaliatory arrests, and is brought to us by the Civil Rights Lawyers channel. Be sure to check out the description below and give them the credit that they deserve. On May 13, 2022, Corporal J.D. Ellison of the Nicholas County Sheriff's Department pulled over a driver for flashing his headlights to warn oncoming traffic of a speed trap in Summersville, West Virginia. The driver, who we will refer to as Mr. Headlights, stopped on the side of the road, and Corporal Ellison approached the driver's side of the vehicle.
That was pretty stupid, wasn't it?
What's that?
Flashing your lights at everybody to let them know that law enforcement was sitting there running radar.
Is that what I did? Is that a crime?
Yeah.
It is? I didn't know that.
You got your license registration proof?
Yeah, I did.
Why would you do that? You're flashing your high beams at people to...
In the daytime?
Yeah.
I didn't know that was a crime.
It doesn't say daytime or nighttime. It just says that you can't do it, and you did it.
Yeah, I'm sorry. I didn't know that was a crime. I didn't know that was
Yeah, you can't high beam people at any time in the daytime or nighttime.
I didn't know that. I didn't know. I mean, nighttime I understand, but daytime I didn't know.
Corporal Ellison claims it is a crime for individuals to flash their headlights, and he eventually issues Mr. Headlights a citation for violating Section 17C-15-26 of the West Virginia Code, which states that, quote, flashing lights are prohibited on motor vehicles. However, it should be noted that the use of the plural verb are instead of the singular verb is indicates that the word flashing is an adjective that modifies the noun lights and not a verb. In other words, the statute prohibits motor vehicles from having flashing lights, but does not prohibit motorists from flashing their lights. Another important factor to consider when analyzing the meaning of this statute is that it is located in Article 15 of the West Virginia Traffic Code, which focuses exclusively on the required and prohibited equipment that must or cannot be installed on certain vehicles. It seems clear from the context of the statute that it bans the installation of lights that automatically flash, but does not prohibit a driver from manually flashing lights that are typically static, such as headlights. For instance, the statute creates an exception to the general prohibition against flashing lights, stating that, quote, any vehicle as a means for indicating right or left turn, or any vehicle as a means of indicating the same as disabled or otherwise stopped for an emergency, may have blinking or flashing lights. This section of the statute inarguably refers to turn signals and hazard lights, both of which flash automatically once they're activated. Similarly, the statute also allows for blue flashing warning lights on police vehicles, red flashing warning lights for ambulances, firefighting vehicles, school buses, and other emergency vehicles, and yellow or amber flashing warning lights for tow trucks, postal service vehicles, and other emergency or service vehicles. The pattern is clear. Whenever the statute mentions a flashing light, it is referring to a light that intermittently and automatically illuminates. Given this context, it seems unlikely that a reasonable court would conclude that Mr. Headlights was in violation of this statute, as his vehicle was not equipped with any flashing lights.
I'm sure I could articulate some other kind of driving charge in there for doing that too. That's pretty crappy.
Yeah, I apologize. I'm just going to call them see if they can send it, because I thought it was
Just, you can hang tight, listen to what he says. All right, so there's your stuff back there. And I wrote you 2 citations today. First one being special restrictions on lamps, which you can read that code, and it says no flashing lights shall be on a vehicle. And at that point in time, you had flashing lights on your vehicle. It's unauthorized.
Well, under the Constitution, it's protected in the First Amendment. Well, I'm going to look into it.
That's in Tennessee.
Yeah, I'm going to look into it. I'm going to see about West Virginia.
Yeah.
Free speech, you know.
Yeah, it's not illegal to do that, to flash and warn, but it's illegal to high beam, and it is legal to have flashing lights on your vehicle, not being an emergency vehicle.
Mr. Headlights argues that he has a constitutional right under the First Amendment to flash his headlights in order to communicate with other drivers. Although the issue has not been considered by the Supreme Court or reviewed by a considerable number of lower courts, several courts have determined that flashing headlights to warn drivers approaching in the opposite direction about a speed trap is expressive conduct that is protected by the First Amendment. As the U.S. District Court for the Western District of Wisconsin summarized in the 2019 case of Obrecht versus Splinter, the First Amendment protects, quote, conduct, symbols, and nonverbal communication that express or convey a particularized message reasonably understood by viewers. For this reason, the court determined that, quote, although the law is far from clear on this issue, the plaintiff, who was stopped and cited for flashing his headlights, had a plausible claim for relief under the First Amendment. In reaching this decision, the court noted that, quote, at least 2 state circuit courts have also found that drivers have a constitutional right to flash their headlights, including the 2003 case of State versus Walker, where the Tennessee Circuit Court in Williamson County accepted a First Amendment defense to the charge of knowingly interfering with an officer from an individual who flashed their headlights to warn oncoming motorists about a speed trap. The court also relied on the 2014 case of Ellie versus City of Ellisville, in which the U.S. District Court for the Eastern District of Missouri recognized the action of flashing headlights as protected expressive conduct, and issued a preliminary injunction forbidding the Ellisville Police Department from continuing its, quote, policy and custom of having its police officers pull over, detain, and cite individuals who are perceived as having communicated to oncoming traffic by flashing their headlamps and then prosecuting and imposing fines upon those individuals due to the chilling effect of this practice on free speech. The Ellie court reasoned that, quote, even assuming that plaintiff or another driver is communicating a message that one should slow down because a speed trap is ahead and discovery or apprehension is impending, that conduct is not illegal, and concluded that the ordinance that the plaintiff was charged with violating, which prohibited the use of, quote, alternately flashing warning signals on motor vehicles, quote, was clearly inapplicable to the expressive conduct at issue. Although there is limited case law on this topic, and the precedent that we have discussed would not be binding on a West Virginia court, there is certainly a strong argument that Mr. Headlights was engaged in protected expressive conduct when he communicated with other drivers by flashing his headlights.
Huh?
I said, I'll see.
Okay. And I could take you to jail today for your unsigned registration card, but I just wrote you a citation for that. That's actually up to 6 months in jail. You think it's funny, sir?
I'll take the ticket, sir.
I know, but do you think this is funny?
I'm allowed to laugh. I can laugh all I want.
Okay. Go ahead and step out here for me.
I didn't do anything.
Sir, I'm asking you to step out the...
Am I being detained?
Yes, sir, you are. Step out of the vehicle.
Are you serious?
Place your hands behind your back for
Are
me.
you serious?
Yes, sir. Place your hands behind your back for
Oh,
me.
man, you're serious, brother.
I'm not your brother.
Believe me, you're not.
Yeah, I'll never be your brother. I'll never be your brother.
Exactly. You'll never be my brother. Just be careful.
I don't want to be your brother.
No, just be careful with me, sir.
Don't jerk away from me.
Just be careful.
Don't jerk away from me, sir.
Just be careful.
Don't jerk away from me.
My wallet is in the car.
Okay, I don't want you to jerk away from me
I was
right
going
there.
away from the traffic.
No, I was putting you in front of my car,
Okay.
which is away from traffic.
You're arresting me for laughing.
No,
I didn't do anything.
I'm arresting you for unsigned registration.
Okay, all right, that's fine.
Okay, so stand right there.
Even though Corporal Ellison does not place Mr. Headlights under arrest until after he laughs, Corporal Ellison claims that he is arresting him for having an unsigned registration card and not his protected speech. According to Section 17A-3-13 of the West Virginia Code, quote, every registration card shall at all times be carried in the vehicle to which it refers, or shall be carried by the person driving or in control of such vehicle, who shall display the same upon demand of a police officer or any officer or employee of the division. Notably, there's no mention of the registration card needing to be signed. However, the prior version of this statute explicitly required that, quote, every owner upon receipt of a registration card shall write his signature thereon with pen and ink in the space provided. This amendment was enacted by House Bill 4345, which was passed on April 19, 2022, but did not go into effect until June 5, 2022. Therefore, at the time of this encounter, the updated law had been passed but was not yet effective. So though Mr. Headlights was technically required to have signed his registration card. Under Section 17A-3-1 of the West Virginia Code, quote, "Any person violating the provisions of this article is guilty of a misdemeanor, and upon conviction thereof shall be fined not more than $500. As we have discussed before on ATA, the Supreme Court held in the 2001 case of Atwater versus City of Lago Vista that the Fourth Amendment does not forbid a warrantless arrest for a minor criminal offense, such as a misdemeanor punishable only by a fine, concluding that, quote, "If an officer has probable cause to believe that an individual has committed even a very minor criminal offense in his presence, he may, without violating the Fourth Amendment, arrest the offender." Accordingly, it is highly likely that a court would conclude that Corporal Ellison would be within his constitutional authority to arrest Mr. Headlights for his unsigned registration card. Likewise, although Corporal Ellison undoubtedly chose to arrest Mr. Headlights because he laughed at him, a court would most likely reject a First Amendment retaliation claim against Corporal Ellison based on this encounter. As the Supreme Court explained in the 2019 case of Nieves versus Bartlett, quote, "The First Amendment prohibits government officials from subjecting an individual to retaliatory actions for engaging in protected speech. If an official takes adverse action against someone based on that forbidden motive, and non-retaliatory grounds are in fact insufficient to provoke the adverse consequences, the injured person may generally seek relief by bringing a First Amendment claim." However, the court also noted that because, quote, "It is particularly difficult to determine whether the adverse government action was caused by the officer's malice or the plaintiff's potentially criminal conduct, when reviewing a First Amendment retaliatory arrest claim, a court must consider, quote, whether the circumstances viewed objectively justify the challenged action, and that, quote, a particular officer's state of mind is simply irrelevant, and it provides no basis for invalidating an arrest. For this reason, the court concluded that, quote, a plaintiff pressing a retaliatory arrest claim must plead and prove the absence of probable cause for the arrest. Here, as long as Mr. Headlights' registration card was actually unsigned, the court would presumably determine that Corporal Ellison had probable cause to arrest Mr. Headlights, and therefore it is highly unlikely that Mr. Headlights would be able to succeed in a First Amendment retaliation claim, despite the fact that Corporal Ellison appears to have arrested him for protected First Amendment speech. Still, it may be possible for Mr. Headlights to succeed in a First Amendment retaliation case in this situation, as his chances of victory would likely be improved by arguing that the traffic stop itself was unlawful retaliation for flashing his headlights.
Do you have any weapons in the vehicle? Okay. Hang tight in front of my vehicle for me. Hang tight right here in front of my vehicle for me.
Corporal Ellison eventually released Mr. Headlights and allowed him to leave with a citation. Instead of paying the ticket, Mr. Headlights fought both charges against him in the Nicholas County Magistrate Court in Summersville, West Virginia. He represented himself in the proceedings, and on October 4th, 2022, Magistrate Michael Hanks convicted Mr. Headlights of the Special Restrictions on Lamps violation while dismissing the charge for the unsigned registration card. Overall, Corporal Ellison gets an F for pulling over Mr.